a lot of people who are detained, a lot of individuals who are detained are calling and they want to be released. Understandably, they are concerned about the coronavirus, and they also see and hear about people getting released. And so they're asking, their attorneys to get them out. And I mentioned the other day about how an attorney can file a motion to reopen a detention hearing. But once a judge has made a determination that an individual should be detained without bail, there has to be some change of circumstance in order for that judge to reconsider their previous decision or another judge's decision to detain an individual and decide, okay, I'm going to change the prior ruling and I'm going to release them on pretrial conditions. So there's, the change of circumstance. There has to be some change of circumstance. You can't just lose a detention motion as a defendant and then in the next week try to, file it again without some change of circumstance. So the question then becomes whether or not this pandemic rises to the level of a change of circumstance. If, for example, there have not been any, cases in a particular jail, or the individual is not sick, or the individual is not at risk of becoming sick. So I know in the last week or so, there were a lot of attorneys filing motions to reopen detention hearings for their clients. And, absent some consent by the prosecutor's office, most of them were denied because, again, the decision, unless there's just some change of circumstance, they're not going to get out. If you get arrested and you've got multiple cases pending, and the decision to detain you is based upon, case number 1, case number 2, case number 3. One of the decisions that the court relies on is the fact that you're a repeat offender. And let's say one of those cases gets resolved or gets dismissed or gets remanded, and now instead of having 3 cases, you've got 2. That will be a change of circumstance. Maybe it's that as the discovery process unfolds and the defense attorney is able to either conduct his or her own investigation and, come up with what would be considered exculpatory evidence. Exculpatory evidence is evidence that would tend to show an individual not being guilty. Inculpatory evidence is evidence that tends to show an individual or defendant guilty. So let's say my investigator uncovers exculpatory evidence from my client. I turn it over to the prosecutor, and I believe that it's evidence that if the prosecutor considers may not go forward on the case, or may decide to go forward on lesser charges. The prosecutor may need time to conduct their own investigation. But in the meantime, I'm going to file a motion to reopen the detention hearing because the facts upon which the court based its initial decision are now in dispute. And not just in dispute, perhaps they can be proven as not being valid. So that could be a change of circumstance. Sometimes you can ask the court to consider if the defendant has a personal circumstance in their family. Perhaps they have a health issue. So it really can be anything. It generally speaking is related to the proofs of their case. That would be, from a defense attorney's perspective, like the best basis upon which to file a motion to reopen a detention hearing. But it's not limited to that.
So coronavirus would likely be a stretch.
I think
just say to file a detention hearing and say, listen, coronavirus. I mean, come on, Your Honor.
Right. I mean, in my opinion, I don't think that the coronavirus in and of itself would qualify as a change of circumstance unless, and this is a big unless, there is proof that it has gotten into that particular jail where the defendant is, or that particular defendant has a health issue or has been exposed to the virus. That would be better. I mean, it's terrible to say, but a motion to reopen related to the coronavirus is, I would suggest, is more likely to succeed if there were circumstances that, you know, perhaps the individual is more concerned about their own personal health specifically than even their case. So there are, right now, as of today, April 1st, there are a lot more cases in the northern part of the state. And there have been reports of the coronavirus infecting, you know, correctional officers in jails up north. Down in the southern part of the state, that's not the case right now. So, you know, in speaking with prosecutors that I know in, you know, Atlantic, Cape May, Cumberland counties, you know, we've been fortunate that as of right now, it has not gotten into any of those county jails. And so the question becomes whether or not a motion to reopen a detention hearing, absent something else, absent a client with a significant health issue that would make them susceptible to, you know, having serious, you know, life-threatening ramifications should they get sick. Absent something like that, or in conjunction with an application that was specific to their case based on the proofs of their case, some other change of circumstance, I'm not sure that right now it would be successful. In other words, you know, just because we have this pandemic going on, that doesn't mean that a defense attorney is going to be successful in releasing all of their detained clients, absent some other specific fact that attorney can point to. Again,